Good morning. My name is Linda Naish. I'm an attorney here at Beresford Booth Law. I work in the estate planning, probate, and guardianship group of our firm. Today is the fourth and final part of our four-part series of Understanding Trust 101. As a refresher, our first three parts of this webinar series has been trying to explain what a trust is, how they work, the terminology involved in a trust, when you might want or need a trust, and what kind of trust would be appropriate in certain circumstances. And now we've gotten to the point where you have decided to create a revocable trust, or you have a trust that has arisen out of perhaps a will or an existing trust. Remember, those are called testamentary trusts. No matter what they're called, all trusts must hold some sort of asset. And this webinar is going to try to go through some of the steps to take to retitle or change ownership of those assets into the name of the trust. So there, like I just said, there's various types of trusts that require funding. A revocable living trust, as we know, is a trust that is created while the grantors or trustors are living. It can be a single person, it can be a married couple, it can be more than two people, but the trust is created while you're alive, and while you're alive, it is completely revocable. You can change, revoke, amend the trust. You can add assets to the trust. You can take assets out of the trust. A testamentary trust, again, is a trust that arises under your will or potentially under your revocable living trust. Testamentary trust merely means that the trust is created upon somebody's death. We also previously talked about irrevocable trusts and the many types of irrevocable trusts that you could have. You could create an irrevocable life insurance trust. You could create an irrevocable special needs trust for a child or family member. Those trusts work the same way, only that once they are created, changes are severely limited, hence the term irrevocable trust. But even so, assets would need to be transferred into or purchased by an irrevocable trust. And we'll talk a little bit about that. But for the most part, we're going to talk about funding your revocable living trust. And as estate planning attorneys who work with clients and take a lot of time and expense to create a revocable living trust, we cannot overemphasize enough the importance of having a fully funded revocable living trust. You went to a great deal of time and expense to create this trust, but it's not going to work if there is or if there are no assets included in the trust. Many reasons for having a revocable living trust is to avoid probate. If your assets are not titled in the name of your trust properly at the time of your death, you're going to have to go through probate anyway. And that wasn't your intention when you created your revocable living trust. Also, depending on how those assets outside of your trust that are held in your own name at that time, just the fact that they are outside of your trust and a probate is needed is one concern, but it also may be that it is a bank account or a brokerage account that you are titled with your spouse as a joint with right of survivorship. And in that case, none of those assets would flow through your trust, so it could inadvertently interfere with your estate planning goals. And you may hear me saying funding your trust. What that simply means is that ownership of the assets are retitled from your individual name or names, if you're a married couple, into the name of the trust and the trustees. So that's what we mean by funding. And here's some typical assets that are normally appropriate for retitling or transferring into your revocable trust. Real estate, bank accounts, investment accounts, stocks, LLC interests, partnership interests, and tangible personal property. One of the pieces of information you should receive from your estate planning attorney after you've created your trust is how do you title ownership? Well, the trust itself is not the owner. The trustees own the property and they hold it for the beneficial interest of the trust beneficiaries. So we have an example here of if John and Jane Doe created a revocable family trust called the Doe Family Trust. Title to any of the assets would be held as John Doe and Jane Doe, trustees of the Doe Family Trust. We like to include the date that the trust was originally created, and then add in any amendments there too. When we talk about some issues a little further on, we will talk about how the length of that title can sometimes be problems with certain types of assets. So real property is the first asset that we tackle when we are funding our revocable trust. So if you own real property in Washington state or out of state, you will need to retitle or change ownership by way of a deed. In Washington state, we use a quitclaim deed that simply says the grantors, the current owners, John and Jane Doe, convey to John and Jane Doe, trustees of the Doe Family Trust, all of their interest in the real estate. Also in Washington state, you are still required to file a real estate excise tax affidavit. However, the fee is nominal. It's $10. The recording cost for a deed in Washington state can sometimes be quite expensive. I think right now the first page of a quitclaim deed is around $200, and each page is an additional fee. So if you have many properties in Washington state that you need to retitle in the name of your trust, that's a cost that you should be aware of. And we can help you prepare deeds to transfer out-of-state property. And we usually like to advise our clients to have an attorney in that state take a look at the deed, just make sure that we have prepared that deed properly. Just remember, if you have real property in Washington or outside of Washington that you have not retitled in the name of your trust, a probate is usually going to be necessary. The next most common type of asset that is going to be retitled are your bank accounts. This would include checking, savings accounts, money markets, certificates of deposit, any type of asset that you would typically hold at a bank or a credit union. And you probably will have existing accounts there. And the goal is to formally change the ownership to the trust, but hopefully the financial institution, the bank, the credit union will not require you to change account numbers or to reprint checks. In our experience, most banks will allow you to continue to use the same checks that just say Jane Doe and John Doe and not have the name of your trust on the checking account. That applies when your trust is a revocable living trust. If it is an irrevocable trust or a testamentary trust, that may be slightly different. You would also continue to use your own social security number, or if it's a married couple, the social security number of just one spouse. You do not have to obtain a separate tax identification number just for the trust, not at this point. Other assets include tangible personal property. We actually do not recommend that you retitle or change ownership of tangible personal property. This would be vehicles, boats, motorhomes, mobile homes, household furnishings, etc. Those items will be generally assigned to the trust so that they can be distributed according to the trust terms. However, actual ownership doesn't change. There's many reasons that we don't recommend, for example, retitling your vehicle in the name of a trust. One situation could be if you got into a car accident and somebody saw that a trust owned the vehicle, they may think that there are deep pockets in which to recover a settlement or something like that. The next big category are investment accounts, also sometimes called brokerage accounts. Typically, in addition to maybe retirement accounts, a lot of folks have a separate investment account in their name or in the name of the married couple. And we would also want to make sure that these accounts are retitled in the name of the trust. This also applies to stock certificates, which can be tricky. You may have to change ownership by going to an online, like a CompuShare website. You may have physical stock certificates that you have to physically turn into the company and have them reissued in the name of the trust. But again, if these assets are not in your trust when you pass away or when the first spouse passes away, that can create trouble, not just with having to open a probate, but also with your overall estate planning goals in your trust. At the end, or as part of your when you complete your revocable trust, when you execute it, your attorney should prepare a generally one-page document called a certification of trust or certificate of trust. It's authorized by statute in Washington State that any other entity or person can rely on this certification of trust so long as it discloses that the trust exists, when it was created, who the trustors are, who the acting trustees are, if it's been amended, and the address, and also the powers of the trustees to act on behalf of the trust. There may be times where the institution, whether it's a bank or a financial investment advisor, doesn't accept the certificate of trust that you'll receive from your estate planning attorney. They may have their own form, which requests pretty much the same information, but they may be required to have that form. That might be part of their internal policy. If you don't have a certification of trust, many times the entity or the business will accept just the portions of the trust that provide all the information that a certificate of trust would provide. So, for example, the first page of the trust listing the trustors, the trustees, and the beneficiary. The last page of the trust showing the trustors and the trustees signed the trust, and then the portion that provides that it is revocable and the powers of the trustees. There are some assets that we do not recommend changing ownership of, specifically retirement accounts. So that includes IRAs, Roth IRAs, 401ks, 403bs, the whole alphabet of retirement accounts should remain in your name or your spouse's name. And our office provides, depending on your estate plan, our office provides instructions of how to update your beneficiary designation under those retirement accounts so that they coordinate with your estate plan. We also do not recommend that life insurance or annuities are retitled in the name of your trust, and that we do not usually recommend that you name your trust as a beneficiary of your life insurance policy or your annuity. Now, to be clear, we're talking about revocable living trusts here. We're not talking about life insurance trusts. That's a completely different advice that's given there. And also, this is not across the board. You may need to name a trust as the beneficiary of a retirement or life insurance policy. For example, if you're a single parent and you have a minor child and you're establishing a trust for their benefit, you would want to name their trust as the beneficiary. So those are kind of exceptions, and there are other as well. But generally speaking, for most folks, creating a revocable living trust, we don't change ownership or beneficiary designations on these types of accounts. Testamentary trusts, like we said, those are trusts that arise upon the death of a person. So typically you may have a will, you may never have had a revocable living trust, you just have a will that says, upon my death, I want to create a trust for my spouse or my children. That would be a testamentary trust. And whatever assets you leave or want to place into that trust would also need to go through the same process that we just discussed. If you had a home that is going to go into a trust for your spouse, we now need to retitle the home out of your name into your spouse, into the name of the trust that is for the benefit of your spouse. Same thing with bank accounts, if that was the case. Now, I will mention for testamentary trusts, and we'll talk about this in a second, you do have to get a tax ID number, but I'm getting ahead of myself there. You can have a testamentary trust arise out of your revocable trust. And this could occur if you have a married couple, John and Jane Doe, they've created a revocable living trust. They've properly transferred all of their appropriate assets to the trust. And then Jane passes away. And according to the trust, on the death of the first spouse, the first trustor, a new trust may need to be created. And so there you have a testamentary trust. And again, you will need to transfer ownership, title of the assets that are currently held in the name of your revocable trust into this trust that's going to support your spouse or your children. One other thing I'll point out is that many times when you're dealing with a testamentary trust, and you're opening up a bank account or investment account, the financial institution or the bank will say, we need to see the trust agreement, we need to see the trust document. Well, there is no separate trust document if your testamentary trust has arisen under your will. So in that case, you would provide a copy of the deceased person's last will and testament, which would include all of the terms of the trust that you are trying to fund and establish. As talked about just a second ago, a trust is a separate entity, and there are times when that trust will need its own tax identification number, sometimes called the EIN. If you have a revocable living trust, you can use your own Social Security number. If you're married and you've created a joint revocable living trust, you can choose to use either spouse's Social Security number. And so any income, any tax documents are going to be generated under your own Social Security number. For a testamentary trust or an irrevocable trust that you create while you're alive, since both of those are irrevocable, you will need to get a tax ID number for that irrevocable trust. You'll need that in order to open bank accounts and to file the trust income tax returns if that becomes necessary. So we've really broadly gone over how to fund revocable living trusts and a little bit of the testamentary trusts. The steps to fund an irrevocable trust, for instance, an irrevocable life insurance trust, are the same. Just as an example, an irrevocable life insurance trust will usually own a life insurance policy. And so you may fund that trust with cash and then have the trust purchase and pay premiums on a life insurance policy. Sometimes the client has an existing policy that they transfer to or gift into the irrevocable trust. That is, again, funding that type of a trust. And those ones are a little bit rarer and require a little bit more specific instructions on how to fund those trusts, how to recognize the gifts that are transferred into the trust. One of the problems that we see come up many times has to do with the banks sometimes not wanting to or requiring you to change your account number. You've had Jane and John Doe have had a checking account at Wells Fargo forever, and they create a revocable living trust, and they go into the bank and say, we need to retitle this. And we have these checks, and this account number is tied to our Social Security deposits or automatic payments. And so they don't really want to have to change their account number. For a revocable trust with simple checking and savings money market accounts, I think most banks will allow you to just keep your same account number, keep just your regular names on the check, Jane Doe, John Doe, and not the name of your trust. The other issue that we run into sometimes is if you transfer, retitle your real property in the name of your trust, and then you maybe go to refinance your mortgage. Some mortgage lenders are requiring clients to pull the house out of the trust back into their individual names, qualify for the mortgage, execute the deed of trust, and then they're free to put it back in. Since it is a revocable trust and there's no change in beneficial ownership, we would argue that that's not necessary, but if your lender is requiring that, that is an additional step you may have to take. You can purchase real property in the name of your trust as well, and you can also sell real property in the name of your trust. And I think those are the other issue is as part of an estate plan, sometimes you do name your trust as a beneficiary. And when we go back to our slide where we've talked about this is how the trust is titled. Most beneficiary designation forms are online. They have a character space limit. And what we recommend is that if you do need to name your trust as a beneficiary for retirement, life insurance, what have you, that you contact your broker or your financial advisor or somebody at the financial institution and let them know you have a specific beneficiary designation. Can you submit it in writing so that, again, your estate plan is not thwarted? And every financial institution, investment firm, they all do it differently. But that is an issue that can come up at times. And that concludes our series on Trust 101. If you have any questions at all regarding the webinar or any estate planning needs or want more information on what types of trusts might be suitable for you and your family, we'd be very happy to talk to you here at Beresford booth. Thank you for joining me today.